Welcome back to State and Local Government and Politics. In Part 11 of Module 8 on the courts, we'll discuss current and future challenges facing the local courts. The civil and criminal caseloads of state and local courts are rising appreciatively, but their resources are not growing to match demands being placed upon a stressed system of justice in America. The threat to physical safety in the courts and its judiciary is a serious one in many places and a quite justifiable concern in some urban areas. Rural courts, with their broad geographic reaches, face challenges not contemplated in American urban centers. The rapidly rising cost of judicial elections in many states reflect the attempts to politicize the courts on the part of some interests, and in the minds of some observers, this movement towards high-cost judicial elections represents a threat to our independent judiciary. The demand upon state court systems is rising in all sectors and at a more rapid rate than the increase of the general population. Court-related violence and courtroom safety is a chronic, costly preoccupation for those professionals working inside the criminal justice system, but it is not one that gets much public attention. Heavy caseloads, the lack of resources, and inadequate courtroom security are a real concern for professionals working in the criminal justice system, but it is the increased politicization of the courts and judiciary that is considered the greatest long-term threat to the state and local court systems. The independence and impartiality of the judiciary, as well as the effective operation of the checks and balances between the three branches of government, are compromised when excessive politicization occurs. Often veiled as judicial reform, political parties and interest groups in some states are trying to alter the process of how judges are selected and retained to change the political makeup of the judiciary. Politicization of the courts and judiciary is the perception that courts function politically and ideologically in decision making rather than objectively. Nowhere has the politicizing of the courts and judiciary been more apparent than in judicial elections, especially in partisan elections. It was the 2002 Supreme Court decision in Republican Party of Minnesota versus White that accelerated the politicizing of judicial elections. Prior to White, judicial candidates in Minnesota, which used the nonpartisan election process for judicial selection, were forbidden from announcing their views on disputed legal or political issues, from affiliating themselves with political parties, or from personally soliciting or accepting campaign contributions. In the White case, the U.S. Supreme Court ruled that these three clauses of the Minnesota Code of Judicial Conduct violated the First Amendment rights of judicial candidates, and in so ruling, invalidated them and all comparable limitations in place in other states. The decision of the U.S. Supreme Court in the White case made nonpartisan judicial election processes nonpartisan in name only. Judicial candidates in states featuring judicial elections can now personally solicit campaign funds from lawyers or litigants. They can engage in partisan political activities, and they can declare their views on virtually any matter of public concern, whether the matter may be a subject of current or future litigation brought to the court. Partisan elections, as noted previously, are increasingly becoming more like those of the other two branches of government, namely expensive, mass media oriented, and rancorous. Surprisingly, in recent years, the most expensive elections have been retention-only elections where voters only needed to decide whether to keep a judge in office. In Part 12 of Module 8 on the courts, we'll discuss state and local courts and sustainability and the conclusion.